Nollkaemper, Andre Nollkaemper, Professor of International Law at the Faculty of Law, University of Amsterdam.
Okay, thank you very much. If I've counted well, this is the 14th presentation in 4 hours. So this is quite demanding on you, but I'll do my best to keep you alive. Thank you very much for the organizers for organizing this event. It's a very major step in the collaboration between Romanian international law and the European Society of International Law, and I hope that more initiatives like this will follow. Now, my presentation builds quite nicely on the previous 2 presentations. What I intend to do in my 10 minutes or so is to take a bit broader comparative perspective and to reflect on the way international law is applied in Europe on the one hand and other parts of the world on the other hand. And I will focus in particular on the application of direct effect. So, despite the fact, as we just have heard, that within Europe there are still major differences between East and West, on the whole it is clear that in Europe we see a sizable number of cases where direct effect is given to international law. Now, what I want to do is to reflect a bit on the degree in which this differs from other parts in the world, and also why this would be so. For the past 10 years or so, I've been running a project called International Law in Domestic Courts for Oxford University Press, and we've compiled about 2,000 cases by now in probably 90 jurisdictions. So we're starting to get a sort of a feeling about the patterns that we see in different states and different regions. Now, it's clear from reading those over 2,000 cases that the overwhelming majority of cases where direct effect is given is located in Europe, broadly speaking. And I would think it's quite clear why this is so. On the one hand, this has been propelled by the Van Genderloos judgment of the European Union, which, even though technically is limited to EU law, in many states it has been difficult for judges to compartmentalize and treat EU law very different from international law. So you see a distinct spillover effect from the direct effect routine of European law, EU law, to other parts of international law. The second main cause of this large number of direct effect in Europe clearly is the European Convention on Human Rights and the case law of the court. Even though technically, as we have heard, the European Convention does not oblige for direct effect, states can simply implement by legislation, it is also clear that in those states that have opened their constitutions, the European Convention and the case law of the court drives and propels the direct application of the rights of the Convention. Now, prima facie, this is very different in other regions. There's no European Union law, no Van Genderloos, there's no European Court of Human Rights. And if you look to Mercosur, so if you look to regional integration mechanisms like Mercosur, CARICOM, ASEAN, and so on, the Andean community, there's very, very little that even remotely looks like their direct effect as we know it in Europe. Still, direct effect is not unknown at all outside Europe. If I count in the 2,000 or so cases, and then it depends a bit on how exactly you conceptualize direct effect. Of course, there are many ways to do this. But my estimation is that there would be between 40 and 60 states that know the practice of direct effect, where there have been cases where courts have given direct effect to international law. Now, the overwhelming majority of that number is located in the United States. But that might also simply be due to the fact that the United States reporters case reporters are the most faithful and diligent reporters anywhere in the world. So we simply have more US cases than from any other state. But if I discount the United States, of the remaining cases, about 30% is coming from Latin America. And there are fascinating cases of direct effect in Argentina, Brazil, Colombia, Dominican Republic, and Chile. About 20% comes from Asia. And there are interesting examples in Japan, Nepal, and even India, although the Indian system prima facie resists direct effect. And there's a wide variety of cases, about 15% of all cases, in Africa, from Benin, Cape Verde, Côte d'Ivoire, Egypt, Ethiopia, Kenya, and Senegal. The interesting thing is that though touching on the monism-dualism distinction for a second, even though superficially we would expect direct effect only in monist states, there's quite a bit of practice where states in so-called dualist quote-unquote states have been able to give effect to international law that in all but form resembles direct effect. So in India and in Kenya, before the change of the constitution that reverted Kenya into a monist state, there are actually examples of cases where the courts have been quite forthcoming in applying treaties of the International Labour Convention, for instance, or the International Covenant also on economic, social, cultural rights, and de facto gave direct effect. Now, on the whole, it remains somewhat of a mixed bag. So even though we may have about 40 to 60 states where direct effect is known, it is also true that the majority of states worldwide does not know direct effect. At least there have been no cases reported of direct effect. It's also clear that those states that know the concept have a fairly limited practice. So even in Argentina, but also in Japan, there are interesting cases, but the quantitative numbers are actually very much lower than they are in any European state. And then, of course, the political contest is much fiercer than in Europe. So if we take a case from Nepal, where the highest court in Nepal was extremely proactive in giving direct effect to the conventional enforced disappearances, it failed to exert any influence on the political branches, which simply refused to act on the order of the court. So the overall picture is extremely heterogeneous. And I would think that this has to tell us something about the concept of direct effect. If you approach it from a global perspective, we have to recognize that direct effect fulfills two quite different functions. In Europe, we tend to think of direct effect as it has been called, a sword, as something that has the power to create an effect in domestic law, and if aided by supremacy, even set aside domestic law. So direct effect is a power of a rule that strengthens the ability of the norm to have a domestic effect. But in many parts of the world, including those where the concept of direct effect is known, direct effect more often than not functions as a shield. It protects the domestic order from international law. Now let me say a few words on both these perspectives. So direct effect as a sort of powerful sword and direct effect as a shield. Again, the sword sort of perspective is in Europe the dominant one. It fulfills both an international ambition and a domestic ambition. The international ambition is that it helps to make international law more effective. It uses domestic courts to give effect to international law. So it's a very internationalist ambition. But comparative research has also made very clear that in most cases where direct effect is used in this function as a sword, it actually serves primarily domestic purposes. And these domestic purposes are that it locks in particular rights and then protects the rights against a change of government. So that's typically the model as we have seen it in post-communist Europe. And we see attempts, but not much more than that, attempts at similar trends in the post-Arab Spring states in North Africa. In Tunisia and Egypt, it has been tried before in Afghanistan and Iraq. So direct effect then, from this perspective, really is a bottom-up process. So whereas in Europe we tend to, in post-Van Genther laws, we tend to think of as direct effect as a sort of top-down phenomenon ordered by the court in Luxembourg. In reality, it is of course a bottom-up process that has been chosen by states for a mix of international law and domestic law reasons. Now this picture then of the direct effect as a sword has to be sort of relativized by looking at direct effect as a shield, and then it becomes very clear that in many states where the concept is known, courts use the concept to keep international law out. So China is an interesting example. Chinese law knows the concept of direct effect, and there are quite a few cases actually on direct effect in China. But most of these are concerned with private international law, so the relationship between private persons. So once a claim is made against a state, courts still may use the language of direct effect, but use it to turn it against international law. And of course there is something to say here from a rule of law perspective. Because many states will take the position that if you have a domestic rule of law, it might upset the domestic rule of law by bringing in norms from the outside that do not have the same rule of law qualities as domestic law. Some people have argued that the rule of law would require that international law is directly effective in domestic law, but that clearly is not the way the rule of law is construed around the world. And interestingly enough, international law itself, of course, protects autonomy, protects democracy, protects the rule of law. And there's an interesting schizophrenic nature in international law, that on the one hand it may have the ambition to overrule domestic law, at the same time it protects the values that might resist the application of international law. Now this shield perspective, looking from a European perspective, might seem outdated. It might seem sort of dualistic, and we might think that international law requires more. But then, and here I continued the last presentation before me, there's a very modern twist to this use of direct effect as a shield. Because all of the concern about the legitimacy of international decisions, Security Council decisions, and so on and so forth. In Holland even, about the legitimacy of the European Court of Human Rights. That debate leads to a sort of concept of direct effect that is not so easily seen only as a sword, but actually might be used as a filter to hinder the effect of international law. Now the interesting point, I would think, perhaps the most interesting point of this analysis, is that direct effect then becomes a political tool that mediates the relationships between international law and domestic law. And the interesting point here is that the courts then are positioned as actors that have to make these political decisions. And we have to recognize that this relationship between international law and domestic law, of course, in large part is also governed simply by the Constitution. So where the Constitution would say constitutional law always trumps domestic law, full stop, then the political branches have made that political choice. But once the concept of direct effect has been introduced, that power, the power to make these choices on the mediation between international and domestic law, is shifted from the political branches to the courts, which then, whether they like it or not, become political players in defining the relationship between the international and the domestic legal orders. I keep it to this. Thank you very much.